Ever wonder about the Seventh Amendment? It's probably one of the most misunderstood and yet most important rights we have. It says, "In suits at common law, the right of trial by jury shall be preserved." Notice that word, preserved, not created. What you probably don't know is that in your family court case, you deserve a trial by jury. But you didn't ask for one. By not recognizing your right to jury by the Seventh Amendment, you allowed the judge to do as he pleases. This right is ancient. The founders saw juries as a critical shield, protecting regular people from the power of the government and the influence of the elite. Civil juries are the ones that decide disputes over money and property, etc. Essentially, if it's a dispute over money or property in which a child is your property, and the dispute is about money, aka child support. But here's the catch. The Seventh Amendment only guarantees a jury in suits at common law. That means it doesn't apply to many modern legal settings, like administrative hearings or cases seeking an injunction. Hey, hold up just a minute. What did he just say? Administrative hearings? Yes, that is exactly who the state courts are. Administrative tribunals. This creates a huge loophole. Congress can actually limit your access to a jury by creating new types of administrative courts to handle issues that were once decided by your peers. But our people say they are the last line of defense for ordinary citizens against powerful corporations and government agencies. In a world of massive lawsuits, the Seventh Amendment is what determines whether your case is heard by a jury of your equals or by a single government-appointed judge. So, what's the difference between a real judge and one of these administrative judges? The distinction is crucial. The Constitution created what we call Article III judges. These are federal judges appointed for life, and their salary can't be cut. This is on purpose. It's designed to insulate them from political pressure and public opinion, so they can make decisions based only on the law and the facts, without fear or favor. They hold the full judicial power of the United States. On the other hand, you have administrative law, judges, or ALJs. These are not Article III judges. They are employees of the executive branch, working for agencies like the Social Security Administration or a state's Child Protective Services. Think about that for a second. The judge in your case might be an employee of the very agency that is prosecuting you. CPS, DCFS, and family courts. This creates a serious potential for bias. Their authority is limited and comes from the agency itself, not the Constitution. Their decisions are often reviewed and can be overturned, and only then can you appeal to a real Article III court. But don't get this wrong. Do not appeal to a higher state court. They are the same administrators as the administrators you just interacted with. You need to file a lawsuit in federal court. These are the ones that oversee administrative judges. You want to get these state judges out of our case and into the hands of the real judges. These administrative courts were created for efficiency, but they were never meant to decide fundamental constitutional rights. So what do you do if you find yourself in one of these administrative proceedings and the adjudicator is clearly biased or violating your rights? You must challenge their authority. You must challenge their jurisdiction. You have grounds for this challenge when the adjudicator shows obvious bias, denies your right to a jury trial for a matter that would have had one at common law, or refuses to consider important evidence. Due process, guaranteed by the Fifth and 14th Amendments, means you have a right to a meaningful opportunity to be heard. This includes presenting your evidence and cross-examining witnesses. If an adjudicator systematically excludes your evidence or limits your testimony, they are violating your basic rights, and the proceeding is fundamentally unfair. This is especially critical in cases involving the removal of children. The Supreme Court has called this a massive deprivation of a fundamental right. It requires clear and convincing evidence and a fair, rigorous hearing. In order to remove a child without a proper hearing, or based on hearsay and speculation, is a profound constitutional violation. The tribunal is acting beyond its powers. But because you did not invoke your Seventh Amended rights, you were probably taken advantage of. In these situations, you must object on the record. State clearly and calmly that the tribunal is violating your due process rights and exercising power it does not constitutionally possess. You aren't just arguing against a bad decision. You are asserting that the entire proceeding is illegitimate. You must demand that your case be moved to a proper Article 3 federal court where your constitutional rights to an impartial judge, a jury, and a fair hearing will be protected. This is the fight for the very forum the Constitution promises you. You must escalate your case to federal court and Article 3 judge if the administrative judge violated your rights. Thanks for watching. If you found this information helpful, please like this video and share with someone who needs it. And for more content that empowers you with knowledge about your rights, stay informed and stay protected.